Court does call the case, People versus Brian Taylor.
Phone Armstrong, Assistant Prosecutor on behalf of the people.
Good morning, Your Honor. Robert J. Kill on behalf of Brian Taylor. Mr. Taylor, would you state your name for the record?
Yes, sir. Brian Taylor.
So that's how we get your clients here, Mr. Killawald, huh? All right, go ahead. I'm sorry.
Judge, it's my understanding there was a previous PCC, the preliminary exam was set, for whatever reason. I've just been appointed on the case. Mr. Taylor is asking that the exam be rescheduled for April 11th. And I would ask if
Well, it's already set. I don't even know why this is back before me.
I don't know. I was just appointed and they told me to do what they told me to do.
Okay.
Your Honor, may I speak when you have a second, please?
Pardon?
Taylor, Mr. Taylor, you and I have been through this. We're getting a preliminary exam date. That's all you need to say.
No, I just want to speak to Your Honor on the record, though, as well. I appreciate you.
You don't have to speak, Mr. Taylor.
I understand I don't have to speak. I want to speak on the record.
About Mr. Taylor.
I'm sorry, I couldn't hear you.
What do you want to speak about?
So previously, back on November the 10th of 2022, we had my PCC conference. During that period of time, I was out on bond, and I asked the courts that my PCC conference be held within an adequate time frame pursuant to MCL 766.4. Since that time frame, they've made me do another PCC conference, which we're currently doing today. I told them that I didn't want to do another PCC conference. I want to move forward with my preliminary examination. I have a motion here that was dated, that it was put in on 11/21 of 2022. The motion says State of Michigan, Brian O. Taylor, and it has your name and the header as well, Honorable J. Cedric Simpson. And it says that in that December 6, 2022 preliminary examination.
Okay, so Mr. Thomas, Mr. Taylor, let me just stop you for a moment. If you want the court to address that motion regarding that, then certainly the court will address that motion.
You are.
I can also go back through the file and I will tell you that typically during that period in time and since then, the timelines have been waived on these cases. To the extent, for whatever reason, yours might have slipped through and it was not waived,
Yes, sir.
then I will be more than happy to set this over before me 2 weeks out. I don't really need a response to any motion from the people. I will let you know, Mr. Taylor, that should I grant your motion, that what would indeed happen is the case would be dismissed. It would not be dismissed with prejudice, but the people would be prepared right at that moment to rearraign you and we start over. And so if that's what you want to do, that's fine. I would also just advise you that should I rule that way, and I will read very thoroughly your motion, but should I rule that way, any time that you have spent in jail is lost time. So what now do you wish me to do?
Your Honor, I guess my thing is pursuant to MCL 766.4, it says the case should be dismissed.
Okay, I know the statute very well, sir.
Yeah.
I do this every week.
Okay,
I understand that. So what do you want me to do?
I want essentially, and it was and I had a couple of things. I'm sorry that I wasn't able to push my whole message out to you, sir. I'm not trying to irritate you either. Also,
I am not irritated. I just need you to tell me what you want me to do.
I wanted to also discuss my bond with you. Pursuant to MCL,
I'm not discussing your bond. What do you want me to do? You have raised an issue before this court. What do you want me to do?
I guess I'd have to talk to my attorney in private, sir, to see exactly how they want to move forward in that aspect of things. But I've been pressing.
Well, that's probably why Mr. Killawald told you not to say anything.
I'm not negating the fact of the matter, sir.
Well, here's what I'm going to do. Mr. Killawald, I understand you want me to set this for exam, or you want me just to adjourn the PCC so you can talk with him and then he can decide? Because if you're going to proceed with the motion, it's going to come before me.
So essentially, are you saying that I would stay incarcerated, sir? If we dismiss the case, I would just be incarcerated, we would arraign me while I'm incarcerated?
I'm not saying anything. I told you what I think would be the likely outcome. I don't answer questions in the hypothetical. Mr. Kilowald, what do you want me to do?
Mr. Taylor, I would strongly suggest we go to exam. You make the final call.
Let's just address my bond, Mr. Kilowald. We'll just proceed in private. We can proceed with the exam, and then after the exam, we want to.
Preliminary examination will be set. The motion then is being waived, Mr. Kilowald. If you wish to raise the motion, I need to know now so it can come before me.
Your Honor, can we speak in a breakout room in private?
No, I'm not giving a breakout room. Mr. Kilowald, what do you want the court to do? You want me to set it for exam, or you want me to set it out a week so you can talk to your client and then he can make a decision as to what he wants to do?
Yeah, let's do that. Let's do that, Mr. Kilowald. Set it out a week and let's address bond today.
Judge, can we set it out a week? And I would just quickly like to address bond.
Probable cause conference will be adjourned in this matter to April 6, 2023, 9 a.m. I'll indicate there may be a motion pending that I'll have to address at that time. As to bond, what do you wish to say?
Your Honor.
Mr. Taylor, just please,
Yes, sir.
please. Judge, it's my understanding originally the bond was set at 15,000, 10%. It's also my understanding, and I can't give you much detail, but Judge Tabby, for whatever reason, jumped the bond up to $250,000 bond. I don't believe there were any infractions or violations. I'm asking this court to please reconsider a $15,000, 10% bond because apparently we're starting this case over.
Ms. Armstrong, response.
Thank you, Your Honor. I do believe that at arraignment, the prosecutor's office had requested a much higher bond than the $15,000 that was ordered by the magistrate. We found it to be too low for this case. It appears, and I wasn't present, but it does appear that on December 6th, that was an exam date, and the bond was changed to this $250,000 cash or surety. I also have a note indicating that if he does post the bond, it should be on a home confinement GPS tether. I believe that is due to the severity of the case, his criminal history, and also his, there's information, and I was trying to find it for Mr. Kilowald. There's a lot of jail calls. I'm trying still to find the exact call, but there's information from my supervisor that the defendant was staying on jail calls, that he was intentionally delaying this case and adjourning out exams. He had said, I want to adjourn the exam because I want to retain an attorney. And then he said in a jail call, allegedly, I'm not going to get my own attorney. I'm not going to retain. I'm only doing this to delay the case. So potentially the victim will end up being cooperative at some point. So there is a concern in this case also with the facts alleged and his criminal history, and also his statements on jail calls that I will, again, still be working on getting from Mr. Kilowald. So I believe the bond is set as appropriate. This is also, it's been set for 4 different exam dates at this point, and they've been adjourned multiple times over prosecutor objection.
Your Honor, may I speak again?
Can I just say one other thing? The defendant's motion that he just previously raised, when I was looking back in the file, there wasn't a note of it initially. That's already been raised before the court, before Judge Tabby. Senior Assistant Public Defender Joy Gaines filed a written motion on this defendant's behalf. His motion regarding timelines has already been denied by Judge Tabby. So I'm not going to hear it again. I'm going to set this for preliminary examination.
Can I speak, Your Honor, on the bond behalf, please?
Kilowald, do you want him to address the court? We can go ahead.
Okay, Your Honor, as far as my bond conditions, I was on a bond for a month and a half. During the time period, that was October 30th until December the 6th, the complaining witness called me. Every time she called me or wrote me in my personal email or wrote me on Instagram, all of these different social media applications, I called the Washtenaw County Sheriff's Department. Not only did I call the Washtenaw County Sheriff's Department, I also called the prosecution department and asked them, what should I do proceeding moving forward with these matters? Because the complaining witness with these allegations obligations placed upon me is calling me, and I don't want to violate any of my bond stipulations. I was very compliant while I was I never violated any stipulations on my bond conditions. As a matter of fact, to be a law-abiding citizen, I called the Washington County Sheriff's Department and sent them over factual evidence of this person trying to contact me. I don't know if she was trying to contact me to get my bond taken away from me. Unfortunately, I went to my preliminary examination as a law-abiding citizen on December the 6th, and my bond was stripped of me. I haven't tried to make any calls to try to be indirect with the courts. I want to get out to obtain my own counsel. That's why I asked for an adjournment on December the 6th when I was essentially, I feel a habeas corpus incarcerated, because essentially MCR 6.106H1 states very clearly, once a magistrate sets a bond, the proceeding courts may not modify, stay vacate, or the release decision except by an abuse of discretion. Judge Tabby just raised my bond because he essentially wanted to raise my bond, not by the structure.
I will presume that he found an abuse of discretion. I understand all of the issues. I just looked through the file. So in regard to the defendants, so that the record's clear, in regard to the defendant's motion that was, I guess, orally raised, that I was trying to give time for a written motion, that has already been filed before this court. It has been heard before the court and has been denied. There is no reason for this court to then hear that motion again. That motion regarding violation, alleged violation of any time requirements, is denied. Regarding the defendant's motion for bond reduction, the court in reviewing the file, the issues that have been raised have also been raised previously before the court. His bond has continued where it is. The court doesn't see any reason to change that. Defendant's motion for reduction of bond is denied. The preliminary examination in this matter, because I'm not going to hold another PCC in this case, preliminary examination in this matter will be set April 11th, 2023, 9 a.m. before Judge Barr. Thank you.
Your Honor, could I by chance get my, I've been trying to get my.
I'm done. I am done.